Okay, let's come back together. We are now entering the Alaska Native Law section of the Alaska Bar Association's 32nd annual, let me make sure I get this right, Alaska Native Law Conference. And we have 4 wonderful panels organized for this afternoon. We'll start with the federal legislative panel, and then followed up logically by the state legislative panel. And then take a short break, and we'll do a case law update, followed by the ethics panel on attorney-client and subsidiaries. So with that, I will turn it over to Walter Featherly for the federal legislative update. Thank you.
Thank you, Ryan. Can everyone hear me okay? Good afternoon, everyone. My name, as Ryan said, is Walter Featherly. I am the executive partner for the Anchorage office of Holland & Knight. And it is my pleasure to introduce to you this afternoon our 2 panelists for the federal Alaska Native update. And the first of our panelists is Miranda Strong. And I just have to, pass on to you what Miranda passed on to me about herself, just because it's just, you know, it's just the quintessential Alaskan story that we all treasure so much living in this great state. Miranda first lived in a double-wide trailer at mile 15.8 on the Kenai Spur Highway, and then became the first in her family to graduate from college and at UAA.
Yes, he was.
Her first job was in road construction. Of course, we have 2 seasons in Alaska, winter and road construction. Now Miranda is an assistant attorney general for the state of Alaska, where she is the special assistant to Attorney General Jonna Lindemuth on Alaska Native matters, tribal liaison for the Department of Law, and the Attorney General's point of contact on land into trust. With that, I'd like to turn it over to Miranda.
Thank you. So I appreciate you guys, your attention after the lunch session. That's always a difficult dance, so no judgment here. If anyone needs to get up and get coffee or take a walk, I have 2 small kids, so I'm very caffeine dependent. So if I see anyone lurking out to get coffee, I will not think less of you. And also thank you to our hosts, the earlier sessions from the Alaska Law Review folks and from the UAA Justice Center were so interesting. I appreciated being able to listen and learn to those, or learn from those rather. And thanks to the Alaska Native Law section of our Bar Association for hosting this conference in the afternoon. And thank you for the invite from Walter to talk to you about land into trust today. It's my contribution to our federal update. It's very timely. As Walter mentioned, we received our first application to take land into trust here in Alaska. Again, it's been a few decades since that's been something that has been open to Alaska Native tribes. So where have we been with that? And before we get too far into my presentation, I was just curious. I appreciated seeing the show of hands from attorneys. Do you mind just throwing that up one more time from attorneys? Great. What about folks in tribal government? Wonderful. From state or municipal government? I know there are a few of my state folks here. You can identify yourselves. We're all friends here, right?
And there's law students.
Yeah, okay. And any students or academics? Wonderful. All right. Well, good. You're absolutely right. I guess I just said state and local, but federal too. They're a big part of this equation. Yeah. Thank you. So this is really great that we can all get in the same room and talk about this, since it is an emerging issue, and I appreciate the opportunity to do that. So the first notice of application that we received on Monday, which was also Governor Walker recognized the second Monday in the state of Alaska as Indigenous Peoples Day. So that was a happy coincidence to receive that application at the same time. And the first application is for the Alaska Native Village of Craig, and I'll talk more about the specifics there, but just to give you an idea of a few of the things that I'll be talking about is some context around land into trust, and then talk a little bit about the state's position, as well as what we're doing as far as stakeholder engagement on land into trust. So back to the context around that. You may hear some people talk about fee to trust, same thing, just different labels. I think the feds like to say fee to trust, but for some reason I just hear land into trust more informally here in Alaska. So it's just one of those instances where, you know, we kind of do our own thing in Alaska. We're unique, right? And what I'm hearing from supporters of land into trust is that they see this as a way to further empower tribes and a way to improve life in Alaska. And, you know, since there has been some controversy around this, on the other side of the coin, I've heard concerns from folks who see this as somehow weakening the state or interfering with resource development or further complicating fish and game management. So that's just kind of a summary. I know there are many individual interests at play there, but that's just a 30,000-foot view from what I've been hearing. So the BIA notice for the first Craig application that we received, there's some copies back on the resource table for folks who haven't seen it. If you want an electronic copy, we have that on the Department of Law's website under our press release with the Craig application. So this, from what we understand from the notice, is one of about 6. I mean, we don't have access, we can't kind of peek behind the curtain to exactly what the BIA has, but as we understand it, there are 6 applications that the BIA has from tribes that are asking the federal government to have land taken into trust. And this information is taken from a February 26, 2015 subcommittee on Indian, Insular, and Alaska Native Affairs. And BIA testified during that hearing. The first one is the Tlingit Haida Central Council at 0.18 acres and 0.03 acres. The next is the Native Village of Fort Yukon at 1.92 acres. The Native Village of Point Hope, a larger parcel at 100,000 acres. Chilkoot Indian Association at 52. And like I said, this is all old information, so it might have changed, but this is just the most recent that I have. The Craig Tribal Association, at that time it was 7.08 acres. Now we know it's a much smaller parcel of 1.08 acres. And the Ninilchik Village Tribe down near my old stomping grounds on the peninsula at 2.3 acres. So there was a great slide by Kim Reitmeyer, and I do not have that slide up, but I just ask you to recall back for the folks of you who saw it, talking about land ownership in Alaska. And this is just to help us put this in perspective, because I know that land into trust is something that only federally recognized tribes can pursue. If you're an Alaska Native corporation, it's not something that's available to you. If you're a non-tribal private citizen, something that's not available to you. So, recalling that slide, you know, it's only 1% of all of the land in Alaska that's privately held. So it's a fraction then of that 1% that's tribally held and therefore eligible to have a tribe request to have it taken into trust. And as far as timeline goes, I mean, my understanding is that a very quick time frame from the time at the beginning of the process to the end would be 6 months to a year, and I would imagine that would be no change in use, so no NEPA requirements or anything like that. But then there are also parcels on the other end of the spectrum where it's been pending for 10 years or so. So it's not something that's going to happen overnight. And a little bit of the history, you know, as I said, it's been a few decades, right, since land into trust has been something that's been available in Alaska, and that's because of Akiachak. That litigation was over whether or not the federal government could take land into trust on behalf of Alaska Native tribes. And so the state spent about 10 years and a lot of money on that litigation, and recently when Attorney General Lindemuth came into office a couple of months ago, the state made the decision not to pursue that litigation anymore. So that's where we're at right now, where we're having this application. The comment period just started, and I'll talk more about the comment period in a little bit. But as far as the state's concerned, I mean, what we're hearing from tribes is that, there are these concerns that we've all heard about, and tribes have come forward and said, listen, we want to have control over child protection in our communities, and control over the crime that's happening in our communities. And so some tribes have been articulating those motivations as reasons why land into trust is something that's attractive. And the state, of course, shares those concerns. And so we're really trying to look at ways to collaborate with tribes on addressing those challenges. Because it's just, it remains to be seen whether land into trust will be effective to combat those issues, or how effective it will be. So one of the things that we're looking at as far as collaboration are government-to-government agreements and other ways that we can innovatively and creatively come together to work sovereign to sovereign on those matters. And another part of that too, in this budget situation too, it's going to take a lot of innovation. But the state is very sensitive to the fact that we're just looking at this one application at a time. We don't want to get into the whole universe of possibilities. We're just going to take it piece by piece, and so that's why we're focusing on the Craig application now. And land into trust, is not a panacea. I listened to Elizabeth Hensley's comments earlier, and if she's still here, feel free to correct me if I'm misquoting you. Oh, good. Feel free to jump in. But what I heard from her is, yes, that it's exciting that we have this possibility, but also that it's not going to be the answer for every tribe. So it's not a universal solution for tribes. But it is really exciting to be working with an administration that is really focused on collaborating with tribes, that's focused on collaborating with other stakeholders, other Alaskans, on ways where we can address rural justice and where we can improve government relations in our state. I know there's a lot of work there to do. And we're doing that in a way where we're recognizing tribal sovereignty. I've been in meetings where tribal advocates have said to me, I've never heard someone from the state say the tribes are sovereign or mention tribes. And for me, as a young attorney coming in, that's just the law, right? And so that's the way that I was operating. But it's been really a good experience being able to meet folks, some of the folks here in the room, and work on projects together. And I appreciate everyone contributing and helping to educate me as I come along and letting me listen and learn from you all. And one thing, too, that the state is very aware of is that land into trust could increase federal funding to Alaska. And I know that that's another thing that's talked about, because unfortunately there are a lot of federal funding streams that are restricted to Indian country or Alaska Native country. So we look forward to further collaboration and work on ways where we can come alongside tribal governments and work on diverting certain matters to tribal courts, for example, continuing to streamline child protection procedures, and as we talked about, seeing what we can do to better address rural justice. So stakeholder feedback is a big piece of this land into trust, because Governor Walker and Lieutenant Governor Malott tasked Attorney General Lindemuth when she started, and after this Accuchak decision was made, not to further pursue litigation with that, to instead go to stakeholders, get input, so that we can look at what the concerns people are instead of going into a zero-sum game of litigation. And that's where we're at right now. With regards to the Craig application, over the next few weeks, because the comment timeline is ticking for us, we'll be gathering information about the application and analyzing the impact of the property. Specifically, BIA invited comments about the impact of taking property off of the tax rolls, jurisdictional issues, or potential land conflicts. But we have a broader outlook, so anybody who feels that there's information that we should be looking at, whether on a supportive or a concerned stance, is more than welcome to send that information to the Attorney General. Her email address is pretty easy. It's attorney.general@alaska.gov. Yeah, there you go. So if you have something specific to the Craig application, we'd ask that you could get it in to us in the next 10 days by the 24th, since we need to submit our comments to the BIA by November 9th. If you'd rather submit your comments directly to the BIA, then you can do that at the Alaska Region office, as I understand it. And BIA folks can feel free to jump in and correct me if I've misrepresented what they're expecting on their side of things. So in addition to collecting comments from people and inviting people to write in and share their outlook on land and trust, we're also planning some outreach with tribes and specific groups like the Alaska Miners Association, the Municipal League, the Alaska Federation of Natives. I'm very excited to get to go to my first AFN convention next week, so hope to see some of you guys there. Also working with the Department of Interior Solicitor's Office and the Bureau of Indian Affairs, the Resource Development Council, some journalists, and Alaska Native corporations. So why would you bother commenting? You guys are all busy people. Well, it's really useful for us on the state end of things as we go through this comment process. And in addition, it's useful as we consider whether or not there should be Alaska-specific regulations. Because as we stated, and as we all know, we're a unique state, and not that we would need those 100%, but that input will be helpful to determine if that's something that we request or not. And moreover, feedback just generally on not just land and trust, but better ways where we can engage on collaborating with public safety and rural justice and empowering local communities and strengthening our economy are all helpful and interrelated to land and trust comments, I believe. So I want to thank you guys for your attention, and I appreciate you. I didn't see too many people even getting up to get coffee, and everyone looks awake. So well done. And I have cards up here and then cards in the back next to the notice of the Craig application. So feel free to reach out to the Attorney General or reach out to me and I can forward that on. Thank you.
Christine Williams is the founder of Outlook Law.
We can skip my intro.
And Christine will probably give an brief introduction about herself, but I just wanted to mention that Christine is going to be speaking on the subject of the litigation that had been pending for many years in federal court, involving a constitutional challenge to the legislation that has the foundation for the Alaska 8A program, or for the SBA 8A program, which the Alaska Native corporations, of course, have been able to use to great effect. And a lot of the, in fact, on Kim's slide earlier today, you could see the revenues for the Alaska Native corporations broken down between 8A revenues and non-8A revenues continues to be a significant portion and has been an even greater part of the economic success and economic engine of the Alaska Native corporations. And that entire program was challenged in court, and just by way of introduction, Christine Williams was the author of one of the amicus briefs that were submitted on behalf of the Native American Contractors Association, and did a fine job with that. And so with that, I'm going to turn it over to Christine.
Thank you. So what Walter was talking about, this was a constitutional challenge to the SBA's 8A program, and it was in front of the D.C. Circuit Court of Appeals, which means the next stop is going to be the Supreme Court. So this was of paramount importance. And I'll tell you a little bit about why we had to raise our hands as Native Americans and say we are different, and here's why in some of this briefing, because of some of the fallout of an earlier case where that was not done. And it was treated as a racial classification, and everybody got smacked because of it. So there's two things I'm going to go over today, and one is the Rafi case, because we did in fact win that case. So that was a great win, and we're very excited about that. As of this morning, I talked to the Department of Justice. They've heard nothing on the appeals rumble. So far that is holding steady, which is a great thing. If it is appealed, it can go en banc or up. And we're hoping that if it goes up, it's cert denied, which means it stands. So we're hoping that that would be the case. So I'll go into that a little bit. I hope this, so this is me. I'm a law professor. There's some students here. They'll contradict that I'm actually a professor in real life in a couple of law and master's classes. I've been a partner at 2 international firms, and I just started my own. So I'm a little bit busy sometimes. So we're going to go over the background of Rafi, the amici on the Rafi case, or amici, as my sister would correct me, decision of the D.C. Circuit Court of Appeals, the potential next steps, and then we really want to talk about US DOT today and .puff, because there was a national policy shift that directly affects ANCs within the last couple of weeks. And we had to fight that very, very hard, and we won that. And so I think it's important that people know about that, because DOT is not putting the word out. Oh, there's a surprise. Okay, so first off, background, we start with the Dynalantic case, and it's a predecessor case. And what happened here is that nobody said Indian law and Alaska Native law and Native American, if it's defined as Indian tribes, Alaska Native corporations, and Native Hawaiians, as it was defined in the Rafi case. When I use that term, that's the definition of that term. It was constitutionally challenged, the SBA's Section 8A program. It was an as-applied challenge to that industry in Dynalantic. It settled, but it nailed the people that were in that industry. The settlement nailed it and said it went away. It doesn't look like it's going to survive, so we're going to settle it, and the settlement will be for 2 years. There are people in this room that were affected by that decision, treated as if they were a racial classification rather than under Indian law, which we're going to go into why that's different and why that's important to make that distinction. So they were nailed. When the injunction could have been lifted on Dynalantic, right about the time when Rafi was coming up for the D.C. Circuit Court of Appeals, letters were written to DOD asking them to go to court and ask the court to lift that injunction, and they said no. So we knew at that point Rafi became even more important, because we were going to keep taking little hits like this all the time and grouped in. Why Dynalantic was going on, the Rafi case was stayed, but was it? When a case is usually stayed, the judge will say, well, this case is going on, this case completely stops. The judge that had Rafi said, well, that case is going on, we're going to stop, but we'll do discovery. The discovery that she allowed was absolutely incredible in the amount and in who did it. The experts were wonderful. The discovery and the disparity studies that came in were the strongest, some of the strongest that they had ever done. Why? Because DOJ just got their their rear end kicked on the Dynalantic case, so they certainly weren't going to lose Rafi. Rafi was a constitutionally facial challenge, whereas Dynalantic was applied. But they went in as if it were an as-applied case. And they went in hard. DOJ went in hard. They were not going to lose the second time around, because they really lost the first time. Okay, there was no distinction made by DOD between Indian groups, so ANCs, tribes, or NHOs, and racial classifications. No distinction, so it hit everybody. So we knew at Rafi that we had to make that distinction. It was summary judgment motions in Rafi because the discovery was allowed to go on. So as soon as Dynalantic settled, Rafi came to life. Rafi was decided on settlement judgment motions, which included depositions and disparity studies. So there was a ton of evidence for these summary judgment motions. The judge came out with a very strong decision. It was on strict scrutiny. She found in favor of the program. At that point, it goes up to the D.C. Circuit Court of Appeals. Rafi versus DOD. Amici for both sides are coming on strong, right? These are two sides that are coming on very strong. Amici on both sides are coming in. Rafi was a woman-owned small business, kind of ostensibly, I want to say, and a hub zone. Had more opportunities for federal contractors than 8A program. Combined had 8%. SDBs, which 8A is a subfactor of, only has 5%. For Rafi, Pacific Legal Foundation and Center for Equal Opportunity, Mountain States Legal Foundation, Center for Individual Rights. These were the parties to watch, not necessarily Rafi, but these guys, the Amicis, were the parties to watch. They were smarter. They were on a case called Adirond, which was the case that really introduced strict scrutiny to racial classifications, even when it was rectifying past discrimination. So these were the guys we were watching. These are the ones that were a lot more powerful, we thought, than Rafi. So the Rafi party. So who do we have coming in for DOD and SBA? NAACP Legal Defense and Educational Fund, and we're all coordinating at the same time. Asian Americans Advancing Justice, Leadership Conference of Civil and Human Rights, and for the Native Americans, this group came together. This is who I represented. Native American, and the reason that it's in this order is this is the way people signed on. Once Congressman Young signed on, we had to stop taking people, because once they've agreed and they've looked over the brief, we're done. We can't. So at 4 hours out, we had to stop. Native American Contractors Association, AFN, Alaska Native Village Corporation Association, National Congress of American Indians, Sovereign Omaha Tribe, Sovereign Winnebago Tribe of Nebraska, Great Plains Tribal Chairmen's Association, ANCSA Regional Association, the National Center for American Indian Enterprise Development, Native American Finance, NAFOA, the Cherokee Nation Business, and the U.S. Congressman Don Young. The senators also wanted to sign on. Their ethics committee came up with a different ethics determination than the House came up with. They could not sign on. There was talk of letters of support, but we just dropped it. We said, we have enough. We have to stop at this point. So all of these people, and when I was talking to Walter Wednesday about this was a team effort. This was a team poll. Every person on this list had a say. And I dealt with more general counsels, more lawyers, people weighing in, and I got to listen and learn so much on this case from the people that contributed to it that had something to say about it. And Bruce even bringing up ANCSA. Christine, hit ANCSA a little more here. Okay. I mean, really, people really helped me out, and it was great. Matt also took me to coffee and in a nice way said a few things. So, okay, so DOD, SBA, they brief it up. They brief it up as a strict scrutiny, the highest standard of review, right? Do you like my Batman cape for Halloween? Anyway, they brief it up as the highest standard of review you can ever have. You're microscopic. Rafi, strict scrutiny, highest standard of review. Amici, except for Native American Amici, strict scrutiny, again, highest standard of review, microscopic review, narrowly tailored, and narrowly tailored means to fit the end. We brief it up, it's rational review. Why? Because it's sovereign to sovereign. It's political and it's economic. It's different relationship. This is why we have to raise our hands. We have to say that we're not going to comment on the strict scrutiny, and by the way, we didn't. We danced a lot in the footnotes, but we did not say it should have been strict scrutiny. And we say it should be rational review, especially for Native Americans, because this is a political and economic relationship. This is in the Constitution. This is affirmed by jurisprudence. And we also have ANCSA. So we came from a whole bunch of backgrounds. NHOs was a little more complicated. They don't have statutes. They don't have the Indian Intercourse Act. They don't have a lot of constitutional background. We have to do it statute by statute with Native Hawaiian law. We have ANCSA for Alaska Native corporations. So we supported the other participants, absolutely. We didn't comment on the lower, the lower court ruling was fabulous, but we did a dance in that we didn't say that it should be strict scrutiny. We just said what it should be for us. So it was quite a dance in the footnotes if you go back and read through. Our main points. Foundation was very strong in Indian law and in ANCSA. Should not find the program unconstitutional on any grounds. Limited time business development program. This becomes very important. You'll see this in the judge's decision. Somebody walked out of there and said, I think they were arguing our brief. I don't think that is necessarily true, but these are the things we hit. We did not talk about the regulations. Why? Because this was a facial challenge to the program. So it was looking at the statute, not how it was applied through the regulations. And it was a nice thing that we didn't do that, because they found the regulations were perhaps not as good as the statute was. Aspirational goals, not mandated. That's another key when you're doing any type of review, that has, whether it's race conscious, race neutral, has anything to do with race, it's aspirational and not mandated. Goals throughout the program, milestones, focus on statute. We focused on the statute, not on the regulations ever. I looked back through this morning. In fact, we didn't mention one regulation. We hit Adirond, which was the first case, and we hit it hard. And I'll explain that later when the judge writes her decision why we hit that so hard. Crossan, Morton, and Moncari head on, as well as quoting Scalia, Justice Scalia, who at that time had not passed. Because we knew we had to appeal to a court, and we didn't know what kind of court we were going to get. This is usually, we had a 3-panel judge. We weren't sure if it was going to be conservative or if it was going to be liberal, so we went everywhere with it. We went neutral. We tried to come meet in the middle. It pleased everybody. We hit hard on the D.C. Circuit precedents that quoted the U.S. Supreme Court. We didn't anticipate one thing that they were going to do, that they fed the other side on oral argument, and I'll talk about that in a minute. Backed up justification for a program if found under strict scrutiny, but did not concede it fell under that. Told stories and quoted cases. The same stuff that Kim quoted today, they shared with me. Backed it up with current statistical data from both participants and the Census Bureau. And I have to tell you that sometimes law students get enrolled in stuff they don't really sign up to do. And they get to participate in cases they didn't know they were going to participate in, like statistical stuff. If they choose to write a paper on this, this may be where you want to go. So, and then corporations also helped out quite a bit. Put it into procurement dollars. We also broke it down. Between 2012 and 2014, 5 non-competitive awards worth over $20 million. Now, of course, we know J&A is up to 22. Were awarded to all native 8A American businesses. In fiscal year 2013 alone, federal government obligated over $459 billion to procure goods and services, of which approximately $164 billion, or roughly 36%, was non-competitive. So we put that in our brief. Let's really talk about what we're talking about. Let's really put what goes to Native Americans out there. Let's really talk about it. Alaska Native corporations derive on average, this was the quotes I had at then, and I'm sure the data has changed now, 34% of revenue from SBA programs. That was a 5-year average. The quote I had was 28% at that year. Now that oil and gas has come up, I would expect that, or has gone down, I would expect that the investing in government contracting comes up as a result. Alaska Native corporations give back to their communities and shareholders 75% of their profits. So that all went into the brief. Whoops. Okay, screwed it up. No surprise there. Okay. So we have a 3-judge panel. So it's Henderson, Griffith, and Pollard. Pollard delivers. Hey, Ryan, can you come help me? Is he around? Okay, thank you. So it's Henderson, Griffith, and Pollard. Pollard delivers the opinion of the court, and Griffith joins and says not a word. Henderson delivers one of the best dissents I've ever seen, 27 pages of dissent compared to 28 pages. So we have a 56-page decision on our hands. So this decision was argued March 10th. It came out like 2 weeks ago. These guys were infighting. And in the decision, they quote each other and take each other down. And it was quite something. First up to bat, standard of review, right? So Pollard goes right for it. Remember how we talked about Adirond, the first case that dealt with strict scrutiny as it applies to racial kind of balancing the scales. If there was racial discrimination, you can introduce something to try to balance the scales back at Adirond. She argued Adirond. Pollard delivered the decision, and she argued Adirond with the SBA. She is intimately familiar with the regulations of the SBA. She is intimately familiar with the statute in and of itself. She was uniquely qualified. Mike? Okay. So did everybody catch that about in the insider baseball with Pollard? Because that was fun. Should I go over it again? Okay, so Pollard delivers the decision of the court. She is one of the attorneys that argued Adirond. Adirond was an SBA decision or an SBA-related decision. She knows the SBA statute like the back of her hand. She is for the program. She's up on the bench feeding DOJ almost their argument, which DOJ can't catch. I mean, you can throw it right over their head. So she feeds them the argument. She is uniquely qualified to deliver this opinion, has got it down pat, and she does that, right? Plus, the amici that are on the other side were against her on Adirond. So you're just sitting there watching this going, ha, 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 ha. But we don't know how the other justices are going to go. This is a 3-judge panel. The gentleman, Griffin, was questioning, but he seemed to be going the other way. Henderson, who delivered the 27-page dissent, did not say one word during the entire oral argument until it was over. And then she said, time to go. And she got up before anybody rose and left the room. And well, okay, we're done. So, yeah. So she gave no clues to how she was going to vote. So we really didn't know how this was going to go down. For one of the, so they say it's facially neutral terms different from other statutes and that expressly limit or racial or ethnic minorities or specifically direct third parties to presume minorities are automatically eligible. Again, it is only a facially constitutional challenge. It's only challenging the face of the, not as applied, but only as it reads. So on its face, it's fine. Contrasted to the SBA regulations. Regulations are what applies the statute. They say those might not be so good. Well, I have some issues with that, but that's for another day. The court also quotes oral argument. It's kind of a rare thing to see an appellate quote oral argument. I was also there for oral argument. I read oral argument. I listened to oral argument. They picked and choose what they quoted from that oral argument to get where they got. Both sides of them did. Not unusual. But it was unusual that they quoted it to begin with, and then they started throwing bombs back and forth. But the majority opinion quoted Rafi, Martin was the attorney, quoted him and kept him to his word that it was facial. His only challenge was to facial. They asked him 3 times. Is your only challenge? It's not to the regulations, right? It's not to the regulations, right? It's not. 3 times he said. So, not so. No racial classification in the statute, so rational review. Socially disadvantaged is neutral on its face. Western states, that's a 9th Circuit case that this is the only good quote out of the entire case. I don't care for this case as much. Regulations may carry it out differently, but it applies to individuals within groups. Aspirational goals, they found, not targets. Those aren't mandated. They're not mandated. They're aspirational goals only. Takes issues with Rafi's contention that the statute operates in a certain way. Notes that Congress found there may be discrimination against certain groups, but that was in the findings. It's not the operational language of the statute, not limited to certain groups, jettisoned earlier language. So she goes back, looks at the earlier language. She said, oh, that's only in the introduction. They got rid of the earlier language that could have made this a racial statute, and they jettisoned it. It's only in the findings anyway. It's not in the operational language, so we're going to skip it. Distinguished earlier case law and regulatory interpretation that was in 1980. Policy points the court makes, which I think are very important. Court will construe the statute to avoid constitutional problems unless construction is plainly contrary to the intent of Congress. The reason that one's important is because later cases hold something a little different on racial cases. Policymakers may act with an awareness of race. This is a big one for us as we argue in Alaska and throughout the nation about why it's different for Native Americans. Policymakers may act with an awareness of race unaccompanied by a racial classification or discriminatory purpose without subjecting the resultant policy to the rigors of strict scrutiny, constitutionality. Oh my God, that's a mouthful. So you can be aware of race without invoking strict scrutiny. That's basically what they're saying. You can talk about it, you can be aware of it, but that doesn't necessarily mean it's going to invoke strict scrutiny, and that's how she justified that it was in the findings and not in the operational. That's how she wound it back in. Mere awareness of race and attempting to solve a problem does not doom that endeavor at the outset. It's how it's applied. Is it a disparate impact? She even goes on and addresses that later. Policy points. Again, she quotes Scalia, she addresses Croson, she addresses Adirond, and she feeds full love in an oral argument. Why is that unusual? She fed it in an oral argument. That case was supposed to be overruled by Adirond. She doesn't think it is. So if this is cert denied, then she may have a point. that you could have a statute in place that could go back and fix past discrimination under rational review. And that's what Full of Love did. And it didn't have to have strict scrutiny. So that's why she brought up Full of Love during oral argument, and she quotes it in her decision. Dissents. She takes after the presumption in the statute, follows and quotes the Federal Register from 1980 forward. So if anybody knows me, they know I love the Federal Register. She is singing my song, right? So I totally follow where she's going. I get her, what she's doing. But she does it wrong. She does it wrong. She doesn't interpret all the regulations, and she doesn't read them as a whole. She doesn't know how they're really actually applied in practice. I can find 1,000 holes in her arguments. She also embraces the view that we put forth as amici. She does do that. Both sides did that throughout their briefing, whether it was subtly, it was very subtle in some cases, but she does it a little more lively. She makes it in parliamentary members of groups versus groups are deemed socially advantaged. This is not necessarily true for regulatory reasons, avoided the dissent. So she makes it, she even puts in quotes the difference between being one person and a tribal group, an Alaska Native corporation, or a Native Hawaiian organization. So the dissent even recognized our points that the amici had made in our briefing. Next steps, this is what Teresa and I were talking about, the DOJ attorney this morning. Silence, so far, it is golden. They offered to settle with us early on. All of the amici parties got together and said, nope, because we're just going to keep settling. The next one's going to keep coming. And this was a good test case, so this is the one we wanted. En banc, maybe they'll, instead of 3, they'll call the whole panel up, or U.S. Supreme cert denied that would be a great result. Then it stands. That would be a great result. Switching gears in the last couple of years, and I'll cover it in about 2 minutes. There's a national policy at the US DOT shift, and this was kind of big. US DOT was refusing to recognize ANCSA. They had some popcorn states that would recognize ANCSA, but unless you were 8A certified, you were going to have different rules apply to you that you weren't necessarily set up because you were set up under ANCSA. And so you might be failing their DBE status. You were. And they were going around and pulling DBE certifications from both ANCs that operate within the state of Alaska and ANCs that operate outside of the state of Alaska. They're actively pulling. So my ego is, as Walter probably alluded to, is none too small. And I took an appeal up internally to the DOT, and I thought, well, I've read their regulations since 1998. I've read every statute that they've passed that has to do with the SBA. They should be recognizing ANCSA and how it interacts with ANCSA. I've read everything. So I lost that appeal. And the reason I lost it, because they refused to recognize ANCSA. And I thought to myself, I'm going to fix your bucket. Literally. Those were my thoughts. I am going to, except there was curse language going on in my head. I was so angry. And so I said, I'm going to fix your bucket. I stopped charging my client, and I took it on. And I started working, and I said, do you guys know that people are not recognizing ANCSA? And all I had to do was tell a couple of people that have a lot more power and a lot more sway than I have that can hold congressional people up to the par. So Senator Sullivan's office took the ball and ran with it. He had Fox, he had all sorts of things going on. And one of the things that was resultant, and the SBA also jumped in and got involved and said, hey, you guys actually do recognize ANCSA because you recognize 8As, but you're not recognizing ANCSA directly. So the SBA was also involved trying to get their analysis correct. So they have all these forces coming together. The state was also involved, Jared Gottfried, and was also involved trying to get people changing and thinking about how ANCSA interacts with DOT. So about 2 weeks ago, testimony of Fox, SBA gets involved, backup supplies, DOT re-examines its position on ANCSA. DOT reissues a policy about 2 weeks ago. DOT issues guidance and spread the word. Because I heard last Tuesday, John Klein and I were presenting last Wednesday on the mentor-protege regulations. This still wasn't being recognized in the state of Alaska. So if you have a company that is not in the 8A program that wants to be DBE certified under the DOT, Disadvantaged Business Enterprise Program, under the Department of Transportation. This guidance is on their website down here. Go to the updated guidance, otherwise you'll never find it. You'll go to the 2002, 2004 guidance. And you guys going to have slides up for this so people can use it. I also printed off about 50 copies of the new guidance because I'm pretty proud of that DOT guidance that they issued. The only thing they did was they quoted 1623 instead of 1626 for ANCSA, so we got that corrected. 43 1626 E12 it interacts with D. So they have updated guidance. So they're now certifying. So the SBA, DOT, 2 senators' offices, and Congressman Young's office all get together and they sit in a room. And they say, are you really not going to recognize ANCSA? I mean, it's kind of the stare-down House of Cards game. I'm not there, right? I'm just hearing it secondhand, dying for it. So, but DOT says, we are in fact going to recognize ANCSA. You're right, we are. Yeah, would you like to confirm our appointee? So anyway, so the ANC status of the parent, the ultimate parent, must be established as it is with other corporations. SBA has agreed to certify size. Here's something that's not in my slides. SBA is going to agree to certify to their size, not DOT size. DOT agreed to that. SBA size standards are higher. That's a good thing. SBA is going to certify to a higher size standard. The request of just like it does in the 8A program, it makes logical sense why DOT would agree to that. The request of certification of size requirement can come from the ANC-owned firm or the DOT recipient state agency. Either or, it can be done. Then the SBA will certify. 8A and 3 years after still have the same eligibility status. SBA is certifying to the SBA size standard, not the stand. Oh, I did put it in there. Okay, maybe I'll take that down before it goes up. But that's a really good thing. So that is now up on the DOT's website as of 2 weeks ago. I think it was 2 weeks ago. Was it, Bonnie? Because I think I called you almost in tears going, we did it. They changed the policy. So that's kind of what I got in the last 2 weeks. Those are 2 big national policy changing kind of stories. Are there any questions?